This year marks a decade of the Commercial Courts Act, which was passed in 2015 to expedite the disposal of commercial suits in Indian courts. Now, India has had a long-standing reputation of being a poor enforcer of contracts. The World Bank's Ease of Doing Business report ranked India at 186 out of 189 on contract enforcement. On the basis of a survey of experts in Bombay and Delhi, it estimated that it took about 4 years to enforce a contract in India. The report has now been discontinued. So perhaps more reliably, we could refer to the 253rd report of the Law Commission of India, which collected data on suits from high courts in India and found that 75% of the suits continued to remain pending more than 2 years after they were filed, and about 25% of them continued to remain pending even after 10 years. So what the Commercial Courts Act sought to do is that it sought to divide suits into contract-related suits, such as suits arising from breach of sale of goods contracts or redevelopment contracts, and suits which are not linked to contracts, such as suits arising from family partitions or defamation and so on. The whole idea was to set up dedicated commercial courts to deal with the commercial suits, and the regular suits could proceed in the regular civil justice system. The idea was that such dedicated commercial courts capacity would in fact spur growth and commerce in India and trickle down to better economic growth for India. 10 years later, it's time to ask, has the Commercial Courts Act delivered on its promises? We use data from the Bombay High Court on all the suits that were filed between 2017 and 2024 to answer this question. We collect data on about 3,000 commercial suits and 3,000 regular suits that were filed before the Bombay High Court from 2017 to 2024. We find that actually the time to disposal for commercial suits hasn't changed at all since 2015. It continues to remain close to 4 years, in fact has increased marginally. More strikingly, we find that regular suits are getting disposed of a year earlier than commercial suits. So clearly, the Commercial Courts Act hasn't really expedited the disposal of commercial suits. Now, while time to disposal is commonly used as a metric for evaluating the performance of courts, it is in fact a misleading metric because the time to disposal only accounts for the disposed of cases. So, for example, if I say that it takes 4 years to dispose of a commercial suit in India, it tells us nothing about the suits that continue to remain pending. So what we do is that we take duration buckets. We ask the question, how many suits continue to remain in the system at different points in time? We do this at the 1 year mark, the 3 year mark, and the 5 year mark. And we find that irrespective of whether a suit is a commercial suit or a regular suit, it continues to remain pending in the system. The same proportion of suits continue to remain pending in the system even after 3 years. In fact, after 5 years, less regular suits continue to remain pending in the system compared to commercial suits. So clearly, even on the duration bucket metric, Commercial Courts Act hasn't really matched up to its expectations. Why is this happening? What explains the suboptimal performance of the Commercial Courts Act? Is it that the rules are insufficient? Is it that enforcement capacity is insufficient? Is it that people are not responding to the reform at all? We find that there is no dearth of rules asking courts to dispose of cases faster. So, for example, the Code of Civil Procedure already has a rule which mandates a maximum of 3 adjournments for civil trials. However, earlier research and lived reality has shown that actually civil suits continue to be endlessly adjourned. We believe that it is in fact the lack of enforcement which creates a litigation culture that incentivizes delays. What do I mean by this? In India, lawyers commonly charge a fee linked to the number of hearings. This in turn creates no incentive for them to expedite the trial for their client and end it. Second, in India, lawyers are also banned from charging a success fee linked to a good outcome of a case, which means that it is there is no incentive for the lawyer to complete the case for his client at all. And for defaulting litigants, in fact, it is in their interest if the case continues to remain delayed. Finally, courts rarely impose costs or penalties on parties that seek needless adjournments. This, in turn, creates a toxic mix of both incentives and no penalties for seeking unnecessary endless adjournments. We believe that fixing this litigation culture is much more important than writing rules on how many times a case can or cannot be adjourned, because it is a litigation culture that percolates to real outcomes. We also find that although the Commercial Courts Act had envisaged dedicated commercial benches for disposing of such suits, we analyze a randomly selected list of judges before the Bombay High Court, and we find that actually judges in the commercial division were assigned even other kinds of matters and were not necessarily dedicated to commercial cases alone. Now, the suboptimal performance of the Commercial Courts Act tells us that writing a law by itself will not create performance. Efficiency and predictability and discipline cannot be legislated. In fact, what we need to do is to pass the reform and then build measurement systems to figure out if the reform is working or not. Otherwise, the law will remain an illusion. Thank you.